camera on, and it's 9:27.
And I'll get you sworn in, sir, if you'll raise your right hand, please. Do you swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Would you give the judge your name, please?
I'll give the judge, Hector Martinez, real estate director for the city of Tucson.
How long have you been employed by the city of Tucson?
A little over 33 years.
And would you give me a capsule of what your different titles and functions were in that 33-year career?
Certainly. 1980, started with the real estate department as a real estate appraiser. Did that for approximately 4.5 years. Transitioned into the city manager's office as special projects coordinator out of the Office of Economic Development. Did that for approximately 8.5 years. Came back to real estate for the second time as real estate administrator. Did that for about 11.5 years. Went to the planning department and then special projects again out of city managers for, God, how many years would that have been? About 6-7 years. And then back as real estate director for almost 3 years now.
Ian, do you have any professional designations?
I hold a real estate appraisal broker's license. When I first started with the city, I was a certified real estate appraiser, and actually took all the coursework with the exception of maybe one course and the final exam for the member of American Institute of Appraisers, MAI designation, as a result of me moving out of the real estate appraisal section and going more into special projects, which is what I favored. And I hold a CPM designation, certified public manager.
You have been produced today as a witness for the city of Tucson. Do you understand that that's who you will be testifying for?
I do.
Your attorney has said that you will be testifying about various of the items listed in the deposition notice, I guess starting with item number 12, which is the City of Tucson Rules, Procedures, and Practice regarding city staff's authority to propose terms for the sale of city real estate. Are you prepared to testify about that on behalf of the City of Tucson?
Yes.
Okay. What are the rules, procedures, and practice regarding city staff's authority to propose terms for the sale of real estate?
We can negotiate upfront certain terms and conditions in an attempt to prepare the best package that will be forwarded to mayor and council. Ultimately, that approval comes from mayor and council, and no legal contractual obligation occurs until such time that that authority is given.
what do you mean that you can negotiate up front? What does that mean?
That means that based on the specific circumstances of the situation, based on professional knowledge, we can propose what we feel would be in the best interest of the city and the community, subject to mayor and council approval.
Well, what does the term negotiate mean to you? What's your understanding of that term?
Defining terms, conditions, timelines for the eventual closure of the transaction. But again, everything is subject to mayor and council approval.
Yeah. Does in your terminology, is what happens internally within the city of Tucson considered negotiation?
It may lead to negotiation. And define what happens internally in the city.
Sure. Here's, I guess, how first I normally understand the term negotiation to be interaction with another party. For instance, if you want to buy a TV, maybe there'll be a price and you will offer something with the seller. That would be something I would consider negotiation. Would you agree that that's a common way that that word and term is used?
Yes, terms, conditions, that it will eventually end to a desired result.
No, I'm saying that the way I understand negotiation is that when you negotiate, you're actually communicating with someone else. If you're a seller, there may be a buyer. There's communication between the two sides. That's negotiation. Do you disagree with that?
No, I don't,
Okay.
in a general sense.
Then the way I understand negotiation is whoever is selling or buying, they make an analysis of what's valuable to them, what they desire. And so that's not negotiation, that would be study, preparation, but that doesn't involve communicating with the other side. Do you?
And that would be the staff involvement that leads to negotiation that I suggested.
Yeah. So, well, I want to get back to what you said. You said that the staff can negotiate up front and develop the best package and then bring that to the city council.
That's correct.
Okay, so you actually, the staff actually communicates with the other side, and there's back and forth dealing before the mayor and council know anything about it.
That's not
Correct?
what he said. That's not what he said.
Well, I'm asking the witness, and he can explain if I suggested something that was different than what you're explaining.
Negotiations would involve talking about terms and conditions with the other party.
Yeah, so the city, it's, you and the city are authorized, or at least it's part of what your practice and procedures are at the city, to actually communicate with the other side and make specific offers, make specific terms, discuss those with the other side.
Yes, with the understanding that we are not authorized to enter into a legal position with that other entity unless, and it's authorized by mayor and council.
Okay. And what you're trying to do there is to put together, you said, a package?
Are we talking generalities, or are we talking specifically to the subject at hand?
Well,
Because if you're trying to define my role in this, whether I was negotiating or whether I was providing information that led to negotiations, those are two different things.
well, I tell you what, I want to roll this back where I started, which is that you're here to testify on behalf of the city of Tucson.
Correct?
And this first topic was the city of Tucson's rule, procedures, and practice regarding staff's authority to propose terms for the sale of real estate.
And I defined that.
Yes, and you said that the staff can negotiate up front to develop the best package. That was your answer, right?
Correct.
Okay. That's why I'm asking you about the package. What do you mean by that?
And I'm asking you, is it a general statement? And the defining position, if it relates to this, I did not negotiate with the other party. I provided information to others that led to negotiations. I was not the negotiation team.
Okay. I appreciate that. But what I'm trying to find out is the rules, procedures, and practice of the city of Tucson, and your understanding of those rules, procedures, and practice, and that may be different from what your individual role was. I appreciate that you can explain your individual role, but do you know that you're here to testify on behalf of the city of Tucson concerning this item number 12?
And it's related to definition, and I've answered that.
Yeah. So my question then is, when you gave your answer about that the staff can develop the best package, what did you mean by that?
In general, it's exactly that. You take the expertise of the different individuals, you present that, again, taking into consideration the specific issues related to the transaction that's being discussed, and you develop a negotiation position that would hopefully benefit the city of Tucson and the community. Then that package, that draft agreement per se, is then taken to mayor and council for authority to legally enter into a contract. That doesn't happen unless mayor and council authorizes it.
Okay. In this case, the details and the package was forwarded to, in the situation of Grand Canyon and El Rio Park, was forwarded to the potential purchaser with details. The package was forwarded to them prior to there being a meeting with the mayor and council and receiving authority. Would you agree?
That's my understanding.
Yeah. And so what my question is, does the city of Tucson, do I understand correctly that, well, do you have any rules within the city of staff's ability to do that prior to mayor and council authorization?
The practice is exactly that way. We take draft agreements to mayor and council. Mayor and council has the authority to either accept what staff has brought forth, or they have the authority to say, we do not like that transaction, we would like you to negotiate these points further.
Okay.
And that happens quite often.
I appreciate that. Let me go back though to, there's 3 items here. One is rules. You understand what rules are.
Mhm.
Next, there's procedures, correct? And then practice. So my question first here is limited to the city of Tucson rules. Are there any written rules related to this?
Note an objection. We started 27 minutes late. We've been, I don't know what the time is. We're 15 minutes in. Start asking about records. That's what you're allowed to ask about. So start asking about them.
Mr. Martinez, my question regards to City of Tucson rules.
We have administrative guidelines on those types of issues, not specifically as you've stated, but negotiations that lead to the sale, purchase of properties in general.
Okay. And is it then, are those rules to be followed by the city staff as they're going through this process?
There are administrative guidelines, yes.
And are there any separate procedures than those administrative guidelines that you just mentioned?
I don't know that I understand the question, but the general practice is, from a practical standpoint, we deliver to mayor and council the most complete package we can in relation to whatever transaction we're dealing with. They have the final authority to accept or reject that before we enter into any legal documents.
Does the City of Tucson has administrative directives related to the sale of surplus properties, do they not?
That's correct.
Are you aware of any City of Tucson rules related to the sale of city property that is not considered surplus property?
No.
In regard to offering to sell El Rio Park, would you agree that El Rio Park was never determined to be surplus property by the City of Tucson?
Yes.
So if the City of Tucson was offering to sell property that was not surplus property, and the City of Tucson only has rules concerning the sale of surplus property, who and how was authority granted to develop a package related to the sale of El Rio Park?
This was developed as a result of a request for proposal that had very specific guidelines as to the type of property that was needed to be able to respond to that request for proposal.
So you're saying that someone says, hey, we want to buy a large piece of property that's well located in the City of Tucson, right?
Mm-hmm.
Did you need to check with the city attorney, check with the city manager? How did you arrive at the decision, or the City of Tucson arrive at the decision that a park that was not considered to be surplus property could be offered for sale?
That decision was made not by me. I was involved as a resource to the team relative to this specific parcel to determine range of values so as to be able to respond to a request for proposal that had very specific guidelines as to the needs of that proposal.
Who made the decision that non-surplus city property could be sold?
You'd have to ask that of someone else.
Well, how was that decision communicated to you?
Project manager for this, Chris Casalimas, requested further information relative to the El Rio golf course, in that he was in the process of responding to an RFP.
Did he send you an email? Did he send you a memo?
Believe it was a phone call, and then we actually met in my office on that Friday.
Were there any written documents, any emails, anything in writing related to this?
Very little.
Yeah, what was in?
Those documents have all been made available to you and Ceci, as well as even the internal documents from the appraiser.
Yeah. You're saying that your initial meeting with Chris Casalemas, that information has been made available to the plaintiff, Cecilia Cruz?
That's correct.
And did you at any time inform anyone within that city structure that there were no rules related to the sale of surplus property? It wasn't authorized by any city rule.
Nor was it being prohibited.
Yeah. Do you understand my
So
question?
by practice, and that's why I answer it the way I am, it's not prohibited either. There are examples of opportunity sales that have been taken to mayor and council that have resulted or will result in the sale of the property.
What do you mean by opportunities?
I can give you an example. Tyndall property that was just discussed last Monday, and a newspaper article came out about it. That was not a surplus property, and resulted in 4 executive sessions with mayor and council, and ultimately direction from mayor and council to move forward to legal documents.
What's Tyndall property?
Tyndall property is a piece of property that was leased, that is leased to a nonprofit entity. There were 3 offers from student housing developers immediately adjacent to that.
What kind of property is it?
It's a property that's used by a nonprofit as a training facility through the handicap.
Okay, so it's a city of Tucson property that the city of Tucson is currently leasing to a corporation.
A nonprofit.
A nonprofit corporation.
That's important.
Sure, okay. It's a property city of Tucson is leasing to a nonprofit corporation, correct?
Correct.
And someone made a proposal that they would like to buy that property.
Correct.
And did you negotiate the sale, or was it discussed by the city as to whether they would be willing to sell that property?
I negotiated the initial offering, presented it to mayor and council, discussed the merits if mayor and council chose to sell it, and that resulted in actually 4 executive sessions before authority to proceed to legal documents was granted just this last Monday.
Okay. You talked about the team.
Mhm.
You mentioned there, what was the team that you speak of?
My notes of the meeting that I had with the team were provided to Ceci Cruz, and I think it's the document that's dated March 21st.
Who were the members of the team?
It was 10th floor staff and myself.
And what does 10th floor staff mean?
I believe there was Deputy City Manager Miller, Assistant City Manager, Chris Casalemas. Again, I don't have the documents in front of me. They should be in your file.
Where's your office in there?
My office is located at the Public Works Building, 6th floor north.
Oh. And you were, you mentioned that you were asked to develop a range of values?
This was a Friday, I believe. Forget the exact date, that I was first contacted by Chris Casalimas, and he was looking to respond to an RFP, and the identified parcel that was going to be included in the RFP was defined as the El Rio Golf Course, and they were requesting a value range for that, for a proposal that needed to be submitted that following Thursday, which would have been, Friday was what, the 11th? No, February. I thought I saw one of the notes here. February 15th would have been the date. That's a Friday. My request and task was to develop as soon as possible a range of values that could be incorporated into the RFP.
And was this, the meeting you said was this at your office? or
My
Chris?
office.
So Chris walked over to your office?
Yes.
Is that right?
That's correct.
And told you that the city of Tucson wanted a value range?
I don't know if he worded it exactly that, but based on the circumstances of the situation and the short timeline that he was under, the best that I felt I could produce was a limited or restricted type of an appraisal for consultation purposes that would provide us a range of value for the subject property.
So you determined that a restricted appraisal, you call it?
Ultimately, that was what was delivered as a result of the short timeline of the assignment.
Okay, but let's take this one at a time.
Okay.
What was your understanding of what the city of Tucson wanted regarding El Rio? What did Casalimas, because this is oral, right?
Yes.
And did you write down what he wanted?
We were actually in my office, and at that time, I don't have an appraisal staff.
Yeah.
So I have a contract review appraiser, and then we have on a list 12, 13 independent fee appraisers that we normally contract with.
Yeah.
We conferenced in, my contract review appraiser talked about the needs as communicated by Mr. Casalimas, and discussed how to best get to a value, range based on the time allotted that could be incorporated into a response to an RFP. That was the assignment.
Okay. So this was a telephone conference
With Mr. Avery.
with who?
David Avery.
And who does he work for?
He is a consultant to the city of Tucson, and is assigned to review appraisals that we receive, and to contract with the appraisers that we have under contract, and help real estate defined scope.
Okay. So, there's a deposition marked as,
This is the document.
as Exhibit 10. And whose handwriting is that?
The document that you're pointing to, sir,
Yes.
is the document that was made available to Ms. Cruz and that came out of the appraiser's file, Singleton and Chandler. And it summarizes very well the discussion that they had with David Every, which talks about the need for the consultation report and the scope.
Okay. So, back to the, thank you. This handwriting then is someone at Singleton and Lee?
It's either it's Mr. Lee himself or Chandler, I don't know, but it came out of their file.
Okay. So, the conference phone call, David, is it Every?
That's correct.
And where's his office?
Here in Tucson.
So, but he's a City of Tucson employee?
No, he's a consultant.
Well, who does he work for?
He is an independent fee appraiser, and he is hired by the city to review appraisers and to hire appraisers on behalf of the city of Tucson and refine the scope of the projects in the report.
And is there a written contract with him as to
Yes.
what he's supposed to do?
Yes,
The City of Tucson has some written rules regarding appraisal reviews, correct?
that's correct.
Does he participate in that process?
He is the designated reviewer for the city of Tucson and follows all USPAP guidelines.
Okay. So this telephone conference on the 15th of February was from your office, and it was a telephone procedure where both you and Mr. Casalemas could talk to David Every?
That's correct.
Okay. And in your understanding, then, tell me what David Every was told of the needs of the City of Tucson in an appraisal.
In my words, and they're captured very well in Mr. Lee's handwritten notes there, that this consultation report was needed to respond to an RFP. It was of a confidential nature, and that the timeline was very short. My memory serves me right, I think, again, this was Friday, late Friday, and we mentioned that we needed the report no later than Wednesday, and that Mr. Avery needed to submit the response to the RFP by Thursday of that day, which would have been, what, the 21st or
Yeah.
22nd?
What was the problem that the City of Tucson wanted the appraiser to examine?
There was no problem. It was a consultation to analyze the value range of the subject property so that Mr. Casalemas could, if needed, incorporate into the request for proposal.
Okay. By value range, do you mean the market value?
Absolutely, yeah, highest price in terms of money that the property could be put to, if so, put in the market.
Okay. And that's what you were asking for is the standard request for an appraiser to determine the market value of real estate based on its highest and best use.
That's correct.
Okay. And that was communicated to David Every.
And Lee ultimately, yes.
are you aware if there was any written request to Mr. Lee, or was the request to Mr. Lee based on a telephone call from Efrey?
I did not write anything to Mr. Lee.
Yeah.
I believe everything was communicated in a verbal manner.
Did Mr. Lee, prior to delivering the appraisal, communicate with you for any information from your office?
I believe we provided him with some exhibits that were incorporated into the restricted report, and I believe I provided him with a little bit more information as I understood the project.
The notes from Mr. Every.
This is actually from Mr. Lee.
Exhibit 10?
Yes. This, in other
Yeah.
words, this came from the appraiser that actually did the review appraiser, and
Yeah.
he's summarizing the conversation he had with Dave Every that defined his scope.
Okay. And the notes from Mr. Lee was that the potential user, which was, he knew it to be Grand Canyon University, I take it?
I believe so. I think at that time we needed to explain to him in order for him to develop a value as to but it was all done under a confidential basis.
And that the potential purchaser could receive a PAD. What does that mean?
No, not receive a PAD. I think what the general discussion would be, the property zone X, in order for it to be put to its highest and best use, it'd have to be rezoned under the city standards. There's two ways of doing it. One is to the normal rezoning process. The other is through what's called a plan area development, the PAD
Yeah.
process.
Okay. So what he, if I'm reading this right, he is saying that the potential purchaser may choose a planned area development zoning, right?
That's what it looks like. I don't know what he was thinking, but it goes along with, from my experience, how you would analyze for highest and best use.
And then was it your anticipation that you would be receiving an appraisal of the market value of the highest and best use of that property from Greg Lee?
It was a requirement for him to provide something to me no later than Wednesday of the following week, so that Mr. Casalimas would have the information necessary to properly respond to the request for proposal, which was the intent of this consultation.
Okay. I'll repeat my question if you don't mind.
Sure.
Was it your anticipation that Greg Lee would provide you with an appraisal of the highest, of the market value of the highest and best use of the El Rio parcel?
Yes.
That is not what you received, wouldn't you agree?
No, that's not correct.
You did receive an appraisal of the highest and best use of the property?
Absolutely.
That the city did?
Absolutely.
Well, what's your understanding of what a restricted use report is?
It's not my understanding it's a defined term. A restricted use appraisal is a conclusion of value or value range based on market data. An appraiser is a reflection of the mirror of the marketplace that's reflected into a report. The difference between a restricted and a summary report is that the summary report only has the salient points. It does not have the content of a summary report, which would have a full discussion of neighborhood data, a full discussion of the comparables. It would have the adjustment grid, all those kinds of things. The restricted report is still based on the reflection of market data, and that information is included in his project file, which was again made available to Ms. Cruz, and a full copy of the appraisal file was also provided to her.
The report that you received, let me- this would be what exhibit one?
12.
Is that the report you received, sir?
That is correct. And
And
this was received and dated February 20th, which would have, well, at the conclusion of values of that Tuesday, I think I probably received it that Wednesday morning. So it was generated within the 4-day time period that we allotted them to do this report. This is why it's a restricted report.
it does not say on the front of it that it is a restricted report. Wouldn't you agree?
If you look at the second page, which is the cover, the letter of transmittal included in the report, the second paragraph, it states, all information pertinent and valuable to there is presented in a restricted use report format. Yes, it does say that.
Mr. Martinez, if you would, I would like you to answer the questions that I asked. And if you've got a problem in understanding it, then perhaps I can restate that. So let me start off again by asking the question, would you agree that on the front sheet of, what's that exhibit number? 12. That it does not say that it is a restricted use report.
Yes,
And that is a violation, is it not, of the appraisal standards?
no,
So in your view, on the appraisal standards, an appraiser can issue a report that says an appraisal that is a restricted use report and not put that on the cover of the report.
yes.
Are you aware of, well, what makes that a restricted use report? What is the definition among appraisers of a restricted use report?
Objection asked and answered. Go ahead, Nancy.
I believe I answered that previously. The restricted report is an appraisal that's reflective of the market. However, the report itself does not contain the elements that would normally be found in a summary report, which include a full neighborhood discussion, comparables, an adjustment grid for the comparables, and comparison discussion in the report, things of that nature.
Okay. But the work file is required to contain sufficient information to write a summary report if requested, correct?
And the file that the appraiser has is to contain all the information required to come to a conclusion toward a restricted report.
Yeah. My question was different.
Okay.
What I said is, do not the appraising standards require that the work file of the appraiser who produced a restricted use report should contain sufficient information for him to prepare a summary report if requested?
Yes.
Thank you. What is a hypothetical condition?
In what context?
In the context of the Uniform Standards of Professional Appraisal Practice, what does the term hypothetical condition mean?
It's case by case. And if it leads to a conclusion of value, the appraiser has to disclose that as part of the appraisal report and how that affected his final determination of value or value range.
Okay. Let me read for you what I believe to be the definition of a hypothetical condition as stated in the Uniform Standards of Professional Appraisal Practice.
Objection. How does this have to do with other records? We're dealing with this record. What are you asking him about other records?
These questions are all directed toward that.
I don't agree, and I would like you to move on.
Okay, well.
If you want to ask him that question, great, but we need to move on. This is not about investigating this report. You have this report and you've had it for 90 days.
I understand that.
Good.
Okay. So, anyway, Mr. Martinez, all appraisers know what the USPAP are. Those are the standard rules for appraisers. Wouldn't you agree?
Yes.
Okay. The hypothetical condition is defined as that which is contrary to what exists, but is supposed for the purpose of analysis. Would you agree that that's what hypothetical condition means?
If you're reading from USPAP, I agree.
Sure, I can. No, let me, do you want to read? So, and what's the, there's a comment on hypothetical condition. Would you read the comment, please?
Why don't you read the comment?
Okay. Comment. Hypothetical conditions assume conditions contrary to known facts about physical, legal, or economic characteristics of the subject property, or about conditions external to the property, such as market conditions or trends, or about the integrity of data used in an analysis. Would you agree that that's a correct statement of what a hypothetical condition is?
Again, That's a defined term in use map, and you're reading it, I agree.
Okay. So in this case, the appraiser assumed a hypothetical condition. He assumed that the El Rio property, for purposes of his analysis, was unimproved, plain dirt, correct?
Is that stated in the report? I don't remember.
Yeah. It says, if you'll take a look at Exhibit 12 on the first paragraph, this letter, February 20, 2013, addressed to Mr. Martinez, it says, at your request, we are appraising the underlying land as if vacant and unimproved. Do you see that?
Right, but it's not stated as a hypothetical situation.
Well, let me ask you this. You would agree, would you not, that El Rio Park is not vacant and unimproved?
Correct.
Okay. So, so then, he's saying that at your request, you asked him to assume as a fact what is contrary to known conditions, which makes that a hypothetical condition.
No, it doesn't.
No?
In the sense that it doesn't meet the definition that you quoted from the use map. What this does, it is a part of the highest and best use analysis that an appraiser would go through in coming to a conclusion of value for any property.
Okay.
If you want me to explain that further, I'd be glad to.
No, I want to stick with this, just to understand this, is, you agree that El Rio has hundreds of mature trees and vegetation, correct? So, but he was asked to assume that it was vacant and unimproved, correct?
Yes.
And that would be contrary to what was known about the physical conditions of El Rio, because it's known that it has trees.
But the assignment was to appraise it to its highest and best use.
Okay. And the, yeah, so, I mean, did you ever communicate directly with Greg Lee?
Yes.
Okay. In those communications, did you ask him to appraise the underlying land as if vacant and unimproved?
I don't know if this was communicated with Mr. David Every or directed with Lee or both, but the assignment was to appraise the property and reflect in the report that value which reflected the highest price that that property could bring if put in the marketplace. And an appraiser will go through the analysis of looking at the property as it is, i.e. a golf course, versus what it could be put to. And that's where the term comes in, highest and best use as a vacant. In other words, and I think Ceci was in a discussion with the appraisers themselves where they explained this, and they said to her, if we would have appraised the property as a golf course, the value would have been in the range of about $3 million. If we appraise it based on highest and best use as a vacant, and that which it could be put to, the value range is $15 to $19 million. That's what the assignment was.
me show you, if we could, let me see, I don't know if we marked that. You know, this is,
I don't.
what exhibit numbers are.
13.
Can you read that? I mean, is it legible?
I can read it. 1 second. So.
Have you had a chance to look at Exhibit 13?
I have, sir.
Yeah, you've seen the previously, haven't you?
I don't think so.
Huh. And did you play any role in the preparation of Exhibit 13?
I didn't participate in the drafting of it. Information that I may have provided to Casolinas may have been incorporated in here.
And how would you have provided information to Casolinas?
It would have been through the appraisal and the meetings that I provided notes to Ms. Tucson, where we discussed different items relative to the property.
And this Exhibit 13 stated February 22nd, 2013. And the appraisal came in on what date, sir?
I believe that came in, it's dated the 20th. I think I received it Wednesday morning, and I believe that the RFP was due on Thursday, which would have been the 22nd.
And this appraisal, do you know how you received it, whether it was in
I'd have to look at my,
email or?
no, I think that was delivered, and I actually had to sit down with Mr. Singleton, or, I can't recall exactly. I know that it was delivered to me, and I had a hard copy of it.
Let me show you what I think is marked as Exhibit 9. And it's a two-page document. Just because I think I received it stapled, I left it that way. But what I'm interested in is the second page. If you look at that, there's a, I don't know what's there's something at the bottom left that says 12. I don't know what that is. Do you know?
No, those are internal codes to Mr. Singleton and Lee.
Yeah.
I recognize the documents.
Well, tell me, what is that document?
This was a copy of an appraisal that was done, and I can't recall what project it was, but what was of interest to me was the discussion relative to rates of return on land and how those are determined. And it was in preparation for me and for the meeting that I had with staff, which we discussed, to discuss the appraisal that had been received and provide further input on transactional issues.
Okay, so this was not part of Singleton and Lee's appraisal report in this case?
It was from a previous report that I had on file that had specific information that would help my discussion relative to return on lands on
Okay. The,
Said return, you want rate of return?
rate of return on land, yeah. Thank you.
Mhm.
in Greg Lee's appraisal, when he said that on page 4, Exhibit 12, that the highest and best use of subject property as if vacant is for future development with a mixed-use project, correct?
Yes.
And had you directed him to appraise that property as if vacant?
I think I answered that. The direction was to appraise the property and reflect in his report that value which indicated the highest price that somebody would be willing to pay for the property.
Okay. So then, do I understand then that the city of Tucson did not instruct Greg Lee to appraise the El Rio property as if vacant?
We may have had discussions as to its present use versus its potential use. Its present use as improved was an interim use, and if appraised would have not resulted in the valid conclusion that, or range that this came in at. That was discussed with Ms. Ceci Cruz, and the appraiser's statement was if we would have appraised it as a golf course, the value would have been in the range of $3 million versus 15 million to 19.
And for tape change. Time is 10:29, going off the record. The time is 12:02, and we're back on the, sorry, 10:30, and we're back on the record.
Do any city documents exist concerning the number of acres that Grand Canyon University anticipated using on its campus?
What was communicated to me by Ms. Castellanos was 100 acres, and that's why I believe that the El Rio golf course property was, that and including other factors, was selected as a possible property for response to the RFP.
Okay. They wanted to buy 100 acres, but did the city of Tucson have any documents indicating that for their campus itself, they would be using 100 acres as opposed to once they obtained a planned area development, they would use other portions of it for other uses?
I don't have those in my file. Somebody else may be.
Was there any discussion in any city document about the effect of mature trees and reclaimed water system on the value of that property as a potential campus?
No.
Okay. You're familiar, obviously, with the University of Arizona, correct?
Yes.
And would you agree with me that the mature vegetation on the University of Arizona campus adds to its value as a campus?
In appraisal theory, improvements, whether it be natural or otherwise, may hinder the highest and best use of the property, and therefore are a burden on the land. And in analyzing property as a vacant, those sometimes become deducts to the value of the property because it takes cost to demo and remove, because it impedes development depending on where those improvements, or in this case, in your example, trees are at. So although aesthetically they may be great for development, they may be an impediment and a burden on the land, depending on the type of development that you're looking to move forward with.
Yeah, my question, sir, was, would you agree with me that the mature vegetation on the University of Arizona campus adds to that campus value as a university?
Objection in what context? Are you asking him about appraisal? Because he just answered it. Aesthetically, generally, what context?
Sure, I'll be happy to do that. Did you ever go to the University of Arizona?
Yes, sir.
Okay. Have you got the nice trees kind of adds to the campus and makes it a more pleasant experience to be on the campus?
Aesthetically, yes.
Okay. And would you consider that that adds to the value of that property as a university campus?
Objection again, in what value in what sense?
If you can't answer, the question is of the witness.
In the before situation, if those trees would have been there and you were looking to develop that campus, those trees would have been an impediment and they would have had to be moved or removed or relocated, which would have been an additional cost of development. So they become a burden on the land as opposed to adding value to the land.
Yeah.
Because it impedes the development. And again, it depends on what development and the vision of the developer.
Yeah. Are you aware that a group did a analysis of the value of trees on El Rio of something like $6 million?
I'm not aware of that.
Is anywhere in the appraisal or the documents, was there a discussion about the mature vegetation and whether or not that would affect the value of the property?
I provided a copy of the appraisal, and I believe that it does not talk to that.
So my question was, are you aware of any analysis anywhere that the city of Tucson has that would be in paper or electronic storage that discusses the effect of the mature vegetation and how that might relate to value and usage?
No, I'm not. But it would be irrelevant to the appraisal that we had commissioned.
Why would it be irrelevant to that appraisal that you had commissioned?
For the reasons that I stated, that improvements, whether it be man-made or natural, when analyzing for highest and best use and the potential redevelopment of property, which would then bring the highest price and the highest value in the marketplace, those improvements become burdens on the land, and there's a cost to remove those.
Well, there may or may not be impediments, correct?
Case by case.
Exactly. And isn't that the kinds of things that an appraiser does, is to analyze whether that is a positive effect on market value or a negative effect on market value? That's the kind of thing that an appraiser analyzes, correct?
That was not part of the design, in that the appraiser did not have a development plan from Grand Canyon that would specifically show the proposed development and the location of trees within the development.
You said the appraiser, what now, did not have?
Nobody had a development plan from Grand Canyon that would show where structures were to be built in relation to the existing trees. That was not part of the assignment. The assignment was to appraise the property to determine highest and best use of the property.
But what I'm interested in is, you just limited it to Grand Canyon.
Your question was not clear, and I gave you an example,
Right.
but that would apply to any type of a development specific to what's there today as far as vegetation. And are you going to design to the vegetation, or are you gonna have a clean slate to design to without vegetation?
Well, the highest and best value, and what you were looking for was a market value of the property, correct?
Yes.
And does that not contemplate that it would be what other potential purchasers in the market would pay and use the property for?
Objection, assumes facts not in evidence, calls for speculation. It's not the issue he was dealing with. Go ahead and answer.
I think I've answered it several times. We were looking for an appraisal that reflected the highest price that the property would bring in if available in the marketplace.
Okay.
And if you consider the existing uses would resulted in a value much less than what the value conclusion was, as it vacant.
Okay. So, but we are agreeable that the market value means the most probable price which a property would bring in a competitive open market. Correct?
Correct?
So that means that the property would be analyzed not solely in terms of Grand Canyon, because a competitive open market would look at everyone. Correct?
And that is stated, correct, and that is stated in the appraisal, and you referred to page 5 of the appraisal and the definition of highest and best use. And
Are you aware of any documents that the city has, and or including this appraisal report, that looks at other legal and feasible uses for a mixed-use property of the El Rio, mixed-use project for the El Rio land?
I don't know that I understand the question. Could you repeat that?
Sure. What I've seen in this appraisal is the appraiser looked only at Grand Canyon University as a potential purchaser or user. Would you agree with me?
No.
Okay.
I would not agree with you.
Okay. Tell me then, because I'm interested in any documents that analyze other legal and feasible users of that property for a mixed-use project. Where would I find that?
The appraiser was reflecting value and what the property could be used for, and that's stated in the appraisal report. That was his assignment. Irrespective of the fact whether it's Grand Canyon or not, what we were looking for was a value range that reflected the marketplace.
Where in this appraisal is there any analysis of other potential users?
The statement on page 4, highest and best use. The highest and best use subject property as a vacant is for future development of the mixed-use project.
Yeah, that's a statement. My question was, where in this appraisal is there any analysis or discussion of other potential users?
Note an objection. What's your basis for asking that question? Your whole request is about Grand Canyon. What's your basis for asking that question?
I'm trying, look,
Look, he's answered you about 8 times, said what it is. Your request, Ms. Cruz's request, is about Grand Canyon. So why are you asking that question?
well, I'm trying to find, as you know, other documents. What I have been provided.
About Grand Canyon.
Yeah, and and about El Rio. And
About El Rio and Grand Canyon.
And
right.
what I've been provided is an appraisal report and analysis or discussion of any other potential purchasers other than Canyon.
And why would there be one?
Well, there would be one and should be one because you've just heard that the definition of highest and best use and market value contemplates that kind of analysis and discussion.
And
We have an experienced appraiser and an appraiser reviewer that has been involved somehow in the process. And I would expect there would be somewhere, there must be somewhere, an analysis. It's required, but I've not seen it. And so if those things exist, that points us to additional documents that should be in existence.
he's told you followed the rules. You're assuming something that may or may not be true.
Look,
And I'll let the witness clarify, but I'm not, you're asking questions that aren't based on any evidence.
look,
No, I'm not.
I'm asking questions, Dennis.
Good.
And
Ask away. Hector, can you, based on that interchange, is there anything you want to explain to Mr. Reisner?
look, the other thing, Dennis, I'd like you to follow the deposition rules of making
Yeah, let's follow the
objections for-
deposition rules, Bill. You've got 4 hours, and we've got 3 witnesses, two now. So do you want 4 hours, or do you want to explain to the judge? Because you keep saying it's one deposition, which I agree with. So let's follow those rules. Now, you keep arguing with him about this one. Let's ask, and he keeps explaining, and you don't like the answer. So you keep asking. So let's get on with it.
If you have objections pursuant to the rule, please enter the,
And I am objecting, asked and answered about 8 times.
okay?
Also assuming facts not at evidence. There's no reason there would be those kinds of records.
Well,
So quit fishing.
well, are you aware of any document that has any analysis of any potential purchaser or users in the marketplace for this property other than what's contained in this appraisal report?
No.
And you had talked before, I believe, about property, the utility of examining an appraisal of property as if vacant. Correct? Well,
It's part of the appraisal process.
yeah.
One looks at what's there today and the potential use that the property could be put to. That's where the term, if you're going to appraise it as to the highest possible use that would bring the highest value, then it would be as vacant.
Yeah.
Unless the present use creates the highest value.
Look at page 2 of Exhibit 12. In that second paragraph, This is the discussion of scope of the appraisal. Are you aware of any analysis or discussion of what's starting on actually page 1, it talks about the scope of the appraisal. And it ends up with looking at what future market expectations might entail. Is there any discussion or analysis in the documents you received about future market expectations?
No, what I received is this document.
And it also talks in the next paragraph about the highest and best use of the subject property as improved. It says both as if vacant and as improved. Are you aware of any analysis or discussion in any document of the highest and best use of the property as improved?
We provided the appraiser with maps, and I think they show up as exhibits to the appraisal as to what is there today.
Yeah.
The summary that you're pointing to in that paragraph, I think, defines what I've been trying to explain to you as to the process that an appraiser goes through to determine value.
The sentence there, the physically possible, legally permissible, and financially feasible uses are analyzed. Is there anywhere in these documents where the physically possible, legally permissible, and financially feasible uses of El Rio were analyzed?
The information that is the basis for the conclusion of value that the fee appraiser came to is based on the information that was found and provided to you in his working file. I am not qualified to answer what his analysis and his thought process was, but other than to say he took all these things into consideration and opine on a value that ultimately, as is stated here, the maximum productive use and use of the subject amount feasible produces the highest net return to the subject, which was the scope.
Yeah. So I wonder if you could answer my question, which was, are you aware of any document that contains a discussion or analysis of the physically possible, legally permissible, and financially feasible uses that the appraiser analyzed of that property?
Noted an objection, asked and answered. He referred you to the appraiser's file. Do you have any additional answer?
No, it's the opinion of the appraiser and the content of his project file that led to a conclusion. We made those records available.
Look, your lawyer, if I understood him, put some words in your mouth, and I want to make sure I understand it. Are you saying that the work file contains an analysis of the physically possible, legally permissible, and financially feasible uses of that property? Is that your testimony?
I said that I wasn't qualified to answer that question in that I was not the appraiser that came to the conclusion of value and that he would be the one to answer.
Okay. Yeah, but my question's a little bit different. Are you aware of any document where there is such an analysis?
I feel I'm being badgered. I've answered that question more than once, and it comes back
Do you mean in-city records?
Yeah. Does the city of Tucson have any analysis, well, I suppose the question would be in terms of what was given to you or by the appraiser. The appraiser here says that he did a certain analysis. I don't see it. It could be there are other documents where it's contained, and I want to know, are you aware of any such document that has such an analysis?
I'm not aware.
Thank you. The, are you aware that whether or not the city of Tucson has ever in the past requested a limited use appraisal that did not follow normal appraisal processes to come up to a market value?
The way that the question is structured is no, all appraisals follow USPAP standards. There are two different kinds that we utilize. That's the restricted appraisal, and it follows USPAP standards. And there's the summary appraisal, which follows USPAP standards.
Was this appraisal reviewed by the city of Tucson staff or any person?
The appraisal, the summary, the restricted appraisal report that we received was not formally reviewed by a review appraiser. He was provided the comparables that were used to determine the range of values.
Who was provided the comparable?
David Everett.
Was provided, what's your understanding of what he was provided?
Just as I stated, that he was provided the comparables that were being analyzed by the appraiser to come to a conclusion of value.
Who was he provided those by? Who provided them to him?
My understanding was that Mr. Greg Lee or Mr. Chandler provided those to him.
And was that at the request of the city of Tucson?
No.
Okay. Do you know why they were provided to him?
No.
The city of Tucson does have a mandatory process related to the review of appraisals, does it not?
Yes, we normally have a full review of appraisals done.
Yeah. Why was that not done in this case?
This was a summary restricted range of value with the understanding that if this developed into a legal transactional project, we would then convert this to a full summary report that would have been fully reviewed.
And did the city have any knowledge of the actual market value of the El Rio property? As of any time prior to the receipt of this report on February 20th?
No.
And was it the city of Tucson's belief that that appraisal actually provided a market value pursuant to appraisal standards?
Yes, provided me a range of value.
Yeah, but pursuant to the appraisal standards that are applicable.
Yes, sir.
So you viewed that yourself as a professional, trained appraiser as receipt of a market value appraisal of El Rio.
Yes.
What, are you aware of any other appraisal where the city has asked the appraiser to assume property as if vacant as part of the appraisal process?
We normally have properties appraised based on highest and best use. If the conclusion of the appraiser is to appraise it as a vacant, that's their determination.
Okay. Then I want to make sure I have a clear answer. Are you aware of any other appraisal requested by the city of Tucson of market value where the city asked the appraiser to approve the property as if vacant?
Objection asked and answered.
Yes.
Give me an example, please.
I-19 in Irvington. 22nd and Keno. 22nd and I-10. They're numerous.
What's at I-19 in Irvington?
These are surplus or potentially surplus properties that are being analyzed to be put in the marketplace for sale.
Yeah. And do you have an appraisal on those properties?
Yes, I do.
Okay. You have one on I-19, where are the other ones?
I-19 in Irvington.
Yeah.
22nd Keno, 22nd I-10 frontage.
And you have appraisals on those?
I have appraisals on all properties that are potentially sellable, or, yes.
Yeah. So what's on the I-19 in Irvington property?
There's, it's primarily vacant. There's a water facility there.
22nd and Keno, what's on that?
Vacant.
And 22nd and I-10, what's on that?
Right now it's vacant.
Okay. So the city of Tucson has requested appraisals of vacant property. So the condition of those properties was that they're vacant, right?
Right.
Yeah. So what I was really asking about is your knowledge of the Tucson asking for an appraisal market value of property that's not vacant,
Okay.
but asking the appraiser to appraise it as if it was vacant. Are you aware of any of those?
Yes. I spoke to the Tyndall property that's currently leased to a nonprofit. The analysis there, again, is, if it's appraised as it with the improvements, the value would be minimal. Is appraised as a vacant with the opportunity for that property to be put to its highest and best use, the value differential is tremendous. That's really the highest and best use definition. When they talk about vacant, it's appraising it as is, basically, with improvements, natural or man-made, versus the assumption that it's available for market-driven types of development that will create the greatest net return.
So do you have an appraisal on that Tyndall property?
Yes.
Yeah, well, what's that property called?
We refer to it as the direct property.
Direct?
Direct, and it's referencing the nonprofit that presently occupies it.
Okay. So, in something like that, the appraiser would look at the value of land, look at the condition of the improvements, and then analyze whether those improvements assist the value of the land, correct? Or whether the improvements would detract from the market value because of some problem with them, correct?
It defines for the appraisal whether or not the improvements are an interim use as opposed to its highest and best use.
Okay.
Yes.
Yeah, but you didn't ask the appraiser to ignore the existence of the building and just give us a number as if this property is totally vacant, correct?
I believe that if we have discussions up front and the conclusion is that the improvements are only interim use, I would have probably said, appraisal is vacant, the determination is made up front, that vacant will create the highest net return to the city.
Yeah. Did you do that in that case?
I can't recall what my specific scope of instructions was on that direct property.
Can you recall any property that was improved where the appraiser was instructed, ignore the improvements, don't discuss them, and don't consider them in arriving at a valuation?
That's not the instructions.
No, my question is, can you recall any?
Yeah, no, we've done that before.
Yeah. When? Where?
You're asking me to go back in time, but we've done that when we determine as a real estate, practitioner and recognize up front that the improvements are, in my opinion, and with the agreement of the appraisers or my consultants, does not provide the highest and best use of that property and that which will result in the greatest net return to the city.
Yeah. So that's discussed in the appraisal itself. That's a key element of the appraisal, isn't it?
You asked if that instruction was provided before the appraisal was done. And then my answer is yes, and I gave you the rationale as to why.
Okay, so you're saying that there are examples in the past where the city has instructed an appraiser to ignore actual conditions, don't discuss, don't analyze the actual condition of the property, but give us a number as if that property is vacant. Is that your testimony?
I don't know if that's, the way you're characterizing it is not the highest and best use analysis that an appraiser will go through. I've explained that an appraiser will look at the present use of the property, whether it's improved or not, and they have to determine whether or not that creates the greatest net return to the city. If there's agreement up front that that will not do that, then yeah, instruction is, appraises it vacant because the highest and best use has been predetermined by discussion.
The who's Jim Rossi?
Jim Rossi is one of my staff.
What's his job?
He's a property agent.
What does that mean?
His current responsibilities are to look at and service requests relative to vacation of properties, whether they're right away and sometimes I'll bring him in discussions relative to properties in general because of his extensive knowledge relative to title, research, and real estate analysis background.
Usually Exhibit 8 for this deposition, which was identified in the deposition notice as A2. Who prepared that document?
This was a combination of discussions that I had with Jim Rossi and myself, and this was prepared by both of us.
And would you describe, please, the process that you utilize in coming up with this the proposal?
It's not a proposal, it is more of a guidance document that I used for discussion purposes with the project team in preparation for the meeting that occurred, I believe, it was that Thursday morning, which would have been, or Wednesday. I don't know if it was a morning meeting or afternoon meeting. It would have been either the 21st or the 22nd. Again, copies of my minute notes, meeting notes were provided to Ms. Ceci Cruz on that, and this was part of the attachment as well as these two that you have that I took forth, and where I was discussing the outcome of the appraisal report, and in a general sense, how transactionally a transaction could come together, and gave options with caveats and offsets that could occur.
So this Exhibit 8,
For internal use only.
you and Jim Rossi, was prepared by the two of you.
Yes.
How was that done? How did you and Jim do that?
I mean, mechanically, I had to explain to him what I was working on. I wanted to keep the information as the project as confidential as possible. I gave him general parameters as to what I was dealing with and asked him to assist me in preparing for this eventual meeting.
Okay. Let me see if I can go through this. Does Jim Rossi work in the same office and you in the same building?
He's one of my staff, yes, he does.
Okay. And where's his office located?
Same floor, down the hall.
Okay. And do you communicate with him by email or memo?
This was done all across the table.
Okay. And did you have anything written that you gave to Jim?
I don't recall. I may have shown him some exhibits. I may have shown him the appraisal. If the values are already incorporated in here, I'm sure I did.
Incidentally, when you would have been, were you communicating with other people within the city by email, like Casalemas or?
Very limited.
Yeah. And when you did that with this project, would you put something on the email that would indicate the name of the project, like project study, Grand Canyon?
I provided all my project file to Ms. Ceci Cruz. You have a copy of it. What I have there is what I produced.
Okay, I'm asking you a question, so.
Right.
So my question was, did you communicate with anyone in the city manager's office, the mayor, any other office concerning what you were working on and concerning this project?
It was primarily through Mr. Casalimas, and then in the meetings that I have notes on that I provided to you, those were the communications.
My question is, did you communicate by email with any of these people?
No, other than what is provided to you in the copies of my file.
The city has a sort of a group email that's used for these projects. Did you have access to those emails?
Whatever was sent to me, whatever I responded to, I provided to you in my copy of my file.
My question is, did you have access to those, to that group email system?
Obviously, yes, since he's told you what he just told you. Why are you, what is the point of that question? He's told you that there was communications to and from, and he's given you what he has.
Yeah, so my question though relates to the email system, whether it's is it project study? Are you familiar with the term project study?
I'm familiar with the general term, yes.
And you familiar with Grand Canyon University?
Yes.
In El Rio? And were you someone that had access to the email system where the city was looking at those projects?
And my answer to you was yes, and what I have in the file, I provided to you.
Okay. The are there any, this Exhibit 8 contains a lot of specific proposals, does it not?
Again, these were guiding thoughts based on information that I had pulled from previous appraisals. And I tried to incorporate that and use this and reference this as part of my discussion with the project team.
My question though was, would you agree that there are a lot of specific proposals in Exhibit 8?
Objection, he answered that. You keep characterizing it as proposals, and he says that's not what they were.
Well, I guess, would you agree that the first 4 words say City of Tucson proposes? Correct?
That's what it states.
Yeah, and this document has a number of at least potential proposals that you were considering, correct?
That I was using as a reference point to that immediate audience, which was the project team, as to potentially how a transaction could be put together.
Okay. What I'm trying to find out ultimately is, are there any work papers that are behind this document? Pardon you?
No, I mean, you have some here,
Yeah.
which I've discussed with you.
Were there rough drafts of this document?
No,
This is it?
that's it.
Yeah. And so, where it says, City of Tucson proposes a development and lease purchase agreement. Yeah. How were you made aware that the City of Tucson would be proposing a development and lease purchase agreement?
No, those are kind of my stream of conscious thoughts as to how a transaction could be put together. And some of the elements that could be incorporated with offsets or not.
Okay. The next sentence talked about examples of costs include decommission existing water features, demolition of existing infrastructure.
Where are you reading from?
Yeah, that's on the first paragraph. I believe it's the third sentence.
I think it's right here.
Oh, okay, demolition. Example was crossing. Again, it comes back to the whole appraisal theory of, do you appraise it as is with improvements, or is it vacant,
Okay.
highest and best use? And if there are improvements, are those decommissioning, demolition, removal of, could those result in diminution of value as deducts to the highest and best use?
Okay, let me ask this question then. Why were you considering decommissioning existing water features? How did that enter into the discussion?
Again, this was our own internal documents.
Yeah.
And what I was probably thinking at the time, I'm sure I was, is taking into consideration, we do have a park. If this property is put to a highest and different use, there are numerous existing lines within the body and internal, workings of the property that would have to be decommissioned, in that they serve no purpose for whatever development is going to occur there. And a potential buyer might look at those improvements as a burden on the land, and they may ask for a deduct against value.
Did you communicate at all with the Parks Department concerning the sale of El Rio?
No.
Were you aware that the Parks Department had been directed to prepare a study of that park, or the El Rio Golf Course property, as potentially incorporating new uses to make it a more family-friendly park?
I believe the community was aware of that, including myself, and that there was a lot written in the newspapers concerning those discussions.
So you were aware that that was going on?
Yes.
Okay. But did you have any communication with the Parks Department concerning the nature of their water features, why they would need to be decommissioned, or if they would need to be decommissioned?
No. My scope was specifically, again, responding to Mr. Casalima's request so that he would be better prepared to respond to the RFP, and it was a matter of value. And these points are in relation to how value, or what things could affect value.
Yeah.
At the next iteration, if we were to go there, into the negotiation stage.
Okay. The actual appraisal, of course, didn't discuss any of the decommission or demolition of existing structures, correct?
We've gone over that, yes.
So your sentence here says that the development lease purchase agreement should be drafted to spell out these decommission and demolition items, and yet unforeseen issues, other unforeseen issues. So at least the decommissioning and demolition was a foreseen issue. That's
There
something
could
that
be,
you,
I mean, that's, you know, if that was to come up in the next iteration of negotiations, had it gone there, at least I was preparing staff that that was a legitimate point of discussion.
there was a discussion of, in here, in your second paragraph, of a initial 15-year term with 9 successive 5-year options. That would be 60 years,
Mhm.
correct? Did-
Is that a yes?
5-year options, that's 25 plus 9, 15 plus, okay, yes,
60 years, right?
I believe so, yes.
Yeah. The city of Tucson has rules concerning the length of leases that are permissible, don't they?
I think there's general framework, but again, mayor and council can give different direction based on the merits of the transaction that they're analyzing.
Sure.
And again, this was, you know, for discussion purposes.
Yeah. What is the city of Tucson rules concerning the length of leases for city property?
As of April of 2011, it's 5 years with 5-year options that would have to be approved by mayor and council.
And how many 5-year options would be permissible under those rules?
It's not specified.
So the rules are that it can be leased for how many years initially?
5.
5, and and any option or a 5-year option can be part of the initial lease.
Yes.
Which?
And again, it's case by case.
Well,
The guidelines are just that. Mayor and council has the authority to authorize deviating from those based on the merits of the specific projects.
so the normal terms are 5 years with a 5-year option is permissible.
And it's not specific as to how many 5-year options.
Okay. Did you check with the city attorney or anyone else when you looked here at the initial term of 15 years with 9 5-year options?
No. I did not. This was in preparation for a discussion where everything that I have here is just that. It's for discussion purposes. It's nothing that, you know, is written in stone. It's for discussion purposes and to help frame, you know, how possibly a transaction could be put together and move forward. Again, everything is subject to mayor and council approval.
Well, in your experience, what's the longest lease term that the city of Tucson has entered into since you've been with the city?
99 years.
And what kind of deal was that? Who was that?
There are several with nonprofits that go for that term.
Okay. Are you, this, of course, is, this was a lease to a profit corporation.
Right.
Tell me, what's the longest lease term of city property to a profit corporation that you're aware of?
It's, I can't give you specifics, but it's probably over 25 years.
And what would that be, do you know?
Maybe Western Emulsions comes to mind. There may be others, depending on the situation. And Tucson Convention Center,
Well, what's Western Emulsions, what's that?
it's a company that we relocated and actually did do a lease purchase arrangement with them several years ago.
Is that, was a building on the property or was it vacant property?
It was vacant.
And you think there was a 25-year,
I don't remember the exact term, but I recall that it goes 4 years, yes.
but had someone, I mean, it seems surprising that a 60-year ground lease would be part of the discussion.
Again, these are just ideas.
Yeah.
And, you know, successive 5-year options, how many, you know, again, this is all for discussion purposes.
Where had you gotten the idea about this? Whose thought was that there could be a 60-year ground lease?
You know, I can't recall exactly how that came about.
Are you aware of any other any communication with anyone in the city saying, hey, let's look at a 60-year lease?
No, I'm not.
You're aware, are you not, that the throughout that entire 60-year period, if there was a 60-year lease, there wouldn't be property taxes paid on that property?
On a lease purchase, there may be, depending on the user, G-plat.
Excuse me? I didn't understand your answer.
There would be G-plat.
What's G-plat?
It's in lieu of real estate taxes that would be paid on it.
Explain to me, I don't know what that is.
It's it's governed by state law, and it's in lieu of real estate taxes, there are still taxes that are paid against the property based on a very specific formula that the state rules govern when it's government property being used for non-governmental uses. Can't give you the specifics of it because I just don't recall.
Yeah, okay, so I need to ask what I had seen documents that indicated that Trio had forwarded documents that the property, if the title remained in the city's name, that the land would not be taxed.
Objection.
Are you saying that you have seen documents or aware of information that the land would actually be taxed?
I've not seen the documents that you're referring to from others.
Well, there's some internal city documents, are there not?
I'm not aware of them, nor have I seen them.
The time is 11:31, and if I may, I'm gonna change tapes. The time is 11:32, and we're back on the record.
Just want to note an objection that I don't believe Mr. Reisner is correctly characterizing what Mr. Castellanos already testified to about taxation. And I don't remember the specifics, but I believe there was a distinction between improvements and the land itself on taxation. Or lack of taxation.
Oh, there's no, I don't think there's any disagreement. At least the way that I recall his testimony, and my understanding is that the real property remains non-taxable, but that improvements may be taxed. Is that your recollection?
That's my basic recollection. I'm not a taxation expert, and I don't remember what he said.
Okay.
But if we have that clarification, that's all we need to do right now.
But you if I understand you, you're saying that you think that real property itself that is, after a ground lease, is taxable.
Also,
Yeah.
note an objection, we're beyond the scope of, about records, now we're discussing taxation.
Well, I'm just, my next question would be if there's any, if he's aware of any document, email, anything in writing anywhere that suggested that there could potentially be taxes paid on real property after a lease.
I didn't provide any, nor am I aware relative to this project.
Okay. There's a potential suggestion in the second paragraph that after the initial 15-year term, the purchase price of the property would remain steady for years 16 through 60 of the lease. How did that term become part of your discussion?
Again, these were just ideas of how transactionally something could come together.
Yeah, my question is, how did, I mean, that's a unusual term, is it not?
I answer, those were ideas that I was putting down on paper.
Well, you just live with my question. Is that not an unusual term for a city lease?
Objection, what do you mean unusual? What does that mean?
Okay, let me start another way then. Are you aware of any other lease where the city has entered into a lengthy lease and then permitted the corporation leasing it to arrive at a purchase price that then would remain steady for the next 45 years? Are you aware of any deal that has this sort of clause in it?
I know of a transaction that speaks to the first part of that. I don't know about the length of that. But the value would stay steady if they chose to purchase the property.
And if I understand this thing, sometime during the initial 15-year term, in this case, Grand Canyon could say, we want a fixed purchase price, right?
We're talking hypotheticals at this point. I mean, this is not...
What are you doing that leads to records? What are your questions here leading to records?
I'll get there, Dennis.
Well, do get there, because we've been here almost 3 hours.
I'm getting there, Dennis. So, do I understand this correctly? That this would, that there would be a purchase price determined, correct?
Yes.
Okay, and that purchase price would remain steady for the next 45 years.
These are all hypothetical here.
Okay, so what I started before was this is an unusual element of a proposal, is it not?
Objection. What do you mean unusual? You're editorializing.
Stick with the rules and...
Yeah, do stick with the rules. Ask him about facts, not about whether things are unusual or anything else.
I get to ask questions.
Yes, you do, if they're within the rules.
Yeah.
Let's get on with it, Bill.
These are within the rules.
No, they're not.
Okay. Can you answer, do you understand my question, Mr. Martinez?
There's an example similar to this, and I can't recall the event.
Okay. So let me just, the question was simple. Is this not an unusual provision?
Define unusual.
I'm asking, please, I'm asking the witness.
No.
It's not on your, okay, can you think of, okay. So what the testimony of the city of Tucson is, no, it actually is usual for us to lease a property for 60 years, and then after 15 years, they arrive at a price, and for 45 years, they don't have to pay it.
Objection. Ask him about El Rio in this case. Not about hypotheticals, not about what's usual, what's unusual. Your questions go to records. We're gonna leave in about 25 minutes.
Yeah, okay.
There is an example to this type of a transaction. They don't come up all the time, but there are examples, and there's more to how this kind of transaction comes about.
Okay.
What this is just are points of discussion for me in preparation for a meeting, not transactional deal points that made to the surface or would have. I was talking about examples.
Did someone suggest this to you?
No, I did. I answered that question before.
Okay, so it's your idea that, hey, this is something to think about.
Right.
And how about the last paragraph?
Okay.
Are there any documents that would provide a background for these suggestions?
No.
And were these, again, your thoughts or Jim, just your ideas?
These are thoughts based on things that are not in this document that I explained and gave examples to perhaps in the meeting, how these types of lease purchase agreements come together. Where during the initial, say, 15 years, the lease payments are of such amount that a portion of the lease payments could apply towards the principal value established on inception. If there are offsets that occur during that term, such as capital investments by the purchaser that go towards something else, then those should be credited against the purchase price, was my thought process.
Let me ask you about item 20, which was the process used in persons who performed a monetary analysis of the various portions of the manager's proposal. So is that something that you're prepared to testify about?
No.
Okay.
Was that other folks?
That was done, as I understand it, by Mr. Castellanos or others in the contract with an economics firm to look at, all those items and translate that into returns to the community.
What I want to do is take a break for some food and then start with your IT guy to talk about starting with item 1.
Okay. I gotta make sure he can do that, because I knew I had him for the morning, but that's fine. I think that's fine.
I guess we're going off the record. The time is 11:43.